Hello and welcome to today's webinar. My name is Claire-Elaine Arthurs and I'm a dispute resolution partner with Gunnar Cook. I'm also a CEDA accredited mediator. So what we're going to be having a look at today is a slightly different view of dispute resolution. I mean, very few people relish the prospect of becoming involved in a dispute, but you will find that conflict can rear its head in a number of ways. So often people have no option, or at least it feels that way. It could be they've got differing viewpoints in a negotiation. It might be that there's been a particularly difficult conversation, or more often, something's not gone to plan and people are looking for someone to blame. It only takes one party to be unreasonable, and usually every party will tell you that's the other one, for the issue to escalate, lawyers become involved, and rapidly you can find that matters are snowballing towards the court or the tribunal. So over the years since becoming a solicitor, I've enjoyed a reputation of being quite a robust litigator, but only when I need to be. And I've probably taken my fair share of cases up to the Court of Appeal and had my successes in litigation, as have many of my colleagues. But I'm sure one of the things that most of them would agree with me on is that actually litigation really is the last resort when it comes to dispute resolution. And that's because it actually isn't the most effective way of resolving a dispute. And I'm going to explain why that's the case in a bit more detail in a moment. So what I'm doing today is I'm almost taking my hat off as a litigator. And I'm going to be looking at this topic really from a slightly different angle. So looking at it from the point of view as a mediator, and also with my sociologist hat on, to see where you can have a more holistic approach that might be more effective to dispute resolution. So what we're going to be having a look at today is the nature of disputes. So why do we have disputes? How do they arise and why does that matter? Looking at objectives and how you manage them. Looking at that elephant in the room, which is emotions, considering influence. We'll then be having a look at the 5 phases of a negotiated settlement. Again, how you can use those phases to best effect a good solution for either yourself or your client. We'll have a look as well at the benefits of direct and mediated negotiation, why those are different, and why negotiation is something that generally will provide better results for you if used appropriately. We'll then have a look at some alternative dispute resolution options, but again, we're going to come at those in a slightly different way, looking at how effective they actually are at resolving disputes. And then finally, we are going to rest back onto litigation, but again, coming at that from a slightly different angle, thinking about it in terms of it being a tool for settlement. So let's start with the nature of disputes. So really, we are looking here at the sociology of law. So it may be taking some of the solicitors who are listening back to their time at university. For others like myself, my first degree was in sociology and cultural studies. So I've always been really interested in why people do the things that they do. So disputes effectively, like a lot of other things, are a social construct. Things that might not bother one individual will bother another. And this could be down to a whole number of different reasons. But essentially, what you need to think about is it's the circumstances surrounding them. And sociologists would call this the cultural paradigm. And that can include their age, their status, their race, their religion, the politics, their financial situation, any number of social constructs that sit around them, which would make this thing be a particular issue for them, whereas it might not be for someone else. And that perfect storm almost needs to be in place in order for the parties to want to actually have a dispute. So this is why William Felsteiner, who was one of the leading solicitors to do work on this, he published his first paper in 1981 in the Law and Society Review. And what he said is the shape of disputes reflects whatever definition the observer gives to the concept. So it really does mean that you could come across the same type of dispute in terms of the legalities again and again. You could say, for example, I'll use examples from property litigation because that's my background, but you could say the principles in one boundary dispute are broadly similar to the principles in another. And that may be correct from the point of view of law, but actually, in terms of that cultural paradigm in which the dispute sits, it will be incredibly different depending on which parties you're dealing with in each scenario. And some of us might say that's what makes dealing with disputes particularly interesting. So what William Feldsteiner concluded was he said, what you've got to understand is a significant proportion of any dispute exists in the mind of the disputants. So what we need to think about then is, okay, if all we're doing then is looking at the bare facts, figures and law to resolve a dispute, but the dispute exists predominantly in the mind of the parties on either side, where is that mismatch there in terms of what we're doing to actually find a resolution? So let's have a look then at how disputes escalate. So we've decided we've got this issue that has arisen, you've got this origin of the dispute, and quite often when you track back in cases, what you will find is that the initial issue that knocked everything off and knocked the wheels into motion actually in hindsight looks relatively minor. So what happens is what's been now termed transformation theory. First off, there is a relatively minor or distinct issue that arises, and it arises within the context that we've discussed just before. The party then names it. They name it as a problem. This then starts the ball rolling. We've got a problem. Now, if it's not dealt with at that stage, it then transforms into a problem where somebody must be at fault. And this is when we move into that blame phase. So we've got a problem and somebody's at fault. So therefore, we start adding in other assumptions, other issues, other problems. The way somebody's responded has not been appropriate, and the issue has become bigger. The dispute is starting to grow. And if it's allowed to keep growing and keep growing, eventually what we come to is the claim phase, which is someone has said, it's your fault and I'm going to take action against you. Now, if we are aware at an early stage when the issue is named that there is a problem there and people have been trained as to how to deal with that, you can find that resolution is actually very easy. But the point at which most things come to lawyers is at the point when either the blame is snowballed or the claim has already got to that stage where a party is feeling there is a claim that they wish to make. So understanding why just knowing what the original problem is may not help you to resolve the whole dispute. You have to have a think about the snowball effect and what else has been bundled up there as it's gone along and the dispute has grown. The other thing that's interesting that comes out of sociology, which can be particularly helpful, is that when human beings resolve a dispute or a conflict, they resolve it actually on 3 levels. And unless these 3 levels are met, they will not feel like their problem has actually been solved. Now, the first level is procedural. When we're dealing with legal disputes, this is fairly easy to see how we can satisfy the procedural angle. Procedurally, we do the paperwork, we sign everything off, the parties walk away, the dispute is done. The second phase is substantive. This is to do with the outcome. Has something actually happened? So has there been a finding in favour of one party? Has there been an agreement to do something with a view to it resolving the actual problem? And again, the vast majority of times when we deal with legal disputes, we will be able to tick the boxes for 1 and 2 very easily. The more difficult box comes into box 3. And this is the emotional or psychological box. This is the box that has the individual that's embroiled in the dispute, thinking about it, interjecting into their thoughts all day, possibly keeping them awake at night. It's the bit that makes them angry. It's the bit that makes them frustrated. It's the bit that makes them want to spend the money on taking the dispute forward. And now, I will be the first one to admit that as lawyers, we tend to be very well trained in terms of procedure and in terms of getting a substantive remedy for clients and recording that. But very rarely do any of us have any training on sitting comfortably with the emotion in the room and exploring that, with actually understanding at that psychological and emotional level where it is that our clients are coming from. And this again may be why a lot of litigators will actually tell you that, they feel they've got a really good result for a client, but they very rarely get thanked. And the reason for this is because what we've done is we've ticked the boxes for 1 and 2, but possibly not 3. And actually, coming back to a general theory of business, customers or clients will remember how you've made them feel, but won't necessarily remember what you've actually done for them. What they take away is that feeling. So all 3 of those elements really need to be present in order for them to feel that their problem was really solved. So if you've not addressed the emotional and psychological aspects of the dispute that you're dealing with, they're going to feel that they've got a result, but perhaps they're not feeling it where you want them to be in order for them to be turning around saying, thank you, you've really made that difference to me. So this might make some sense then of some research that CEDA did into why negotiations fail. And these are looking generally, some of these at mediated negotiations, but more generally at negotiations undertaken in writing between parties or in without prejudice meetings. And the 4 key things that they found in all of their studies was that if there was distrust, a lack of realistic assessment, heightened emotion, or other blocks of communication, the chances are the negotiation was going to fail. So distrust obviously has come out of this blame snowball effect. Lack of realistic assessment, well, again, that can come out of the fact that perhaps if we've not addressed the emotions in the room, addressed why people are so angry and so frustrated, which may have nothing to do with the legal issue in hand, then perhaps we will find that their expectations of what they think they should get, what they think they want, are not going to be realistic. I had one mediation that I worked in with an individual who was looking for compensation for pain and suffering. And they said to me, well, I've been asked to put a price on the impact that this has had on me. So that figure there that they're trying to give me is the value on me personally. Now, obviously, that's not how it's assessed on a legal basis, but that was their feeling. And until that feeling could be dealt with, their expectation, their assessment of their position was never going to be realistic. Heightened emotion explains for itself. When you're angry, you're going to dig into a position. When you're frustrated, you're unlikely to want to be coming to the table to try and reconcile and look for a solution. And then communication, it comes back to this key thing. If there's blocks in the communication, the parties aren't openly communicating with each other, then it becomes much more difficult for you to find a solution. But again, they're not going to be open and trust each other and communicate with each other while they're still having to deal with those emotional or psychological blocks. So moving on from that then, I'm not suggesting here that we should all suddenly start navel gazing or hugging each other, but I think really it is just worth bearing in mind that elephant in the room of the emotions and the psychology behind disputes when we're considering how strategically we're going to deal with them. And in particular, when we're looking at what is the objective here. So we need to understand where the client or where we are coming from in relation to a dispute before we can draw a roadmap of where we're going. If we don't understand the nature of the problem that we're dealing with, it becomes very difficult to solve it. So we need to know where are we going and why are we going there? And what's the real problem here? Is the problem the fact that the clause wasn't properly drafted? Or is the problem something to do with the reason why the trust has broken down between the 2 parties? If the issue there is that the document has actually just not been drafted and we need to sort that out, great, we know how to do that. But actually, it may be that the thing that really needs to be resolved is the lack of trust between the parties that we're dealing with, and that's the only thing that's going to be able to put the project or that relationship back on track or allow them both indeed to walk away. So we need to get really clear at the beginning of any dispute that we get involved with, either personally or as solicitors, about what the objectives actually are. Because if we don't meet those objectives, we could get the best outcome at court, but we're still not going to have that feeling behind it then that the problem has actually been resolved. The other thing to bear in mind here is influencers. And what I will say here is that it's not necessarily just about our client when we're considering this stage. Influencers can be external pressures. They would be perhaps people, a manager, a spouse, a friend who's having an impact in how the dispute is escalating, snowballing, and might be resolved. It could be something institutional, like a policy or a procedure or a framework that we have to work inside. It could be cultural, political, or religious. But what we really need to bear in mind here is whenever we're dealing with a dispute, often it's not just the parties on either side who are involved. There are quite often a number of stakeholders who surround them, be it on a personal dispute or on a commercial dispute. We need to have a think about who else do we need to take into account, who are they answerable to, who else needs to be on board with the strategy that we're following, who else needs to approve any kind of settlement or resolution. So we need to know what's driving each side of the dispute, because it might not necessarily just be the individual that we're dealing with. Now, I said earlier that I would have a talk about the 5 phases of a negotiated settlement. Now, in fact, you could probably break down that journey through negotiation in a number of different ways. But being that I am a fan of CEDA, that's the approach that I tend to use when I'm explaining it. So what we're looking at here is the 5 phases of a negotiation. So we've got a dispute that's been established, and what we start off with is that preparation stage. That's when we explore what is going on our side of the dispute. It's when we consider, why has this dispute arisen for us? What's influencing us? What stakeholders have we got? What evidence have we got? How are we going to test our case? What's our objective? So there's an awful lot of work actually to be done at that preparation phase to make sure that we really understand where we're coming from before we move on to the opening. And what that will do at that preparation phase, if it's done properly, is it will allow a tactical approach to the strategy when you're actually opening negotiations. You can decide strategically what you want to share, what you want to hold back, what you want to tell them about what you actually want. Quite often people will launch in straight at the beginning without actually having done that work, whereas sometimes just that little pause to hold back, do a little bit more explanation, have a bit more of a think about it before you engage with the other side will make all the difference in how quickly you're going to be able to resolve the issue. So we move on then to the opening. Both parties share what they want to share. And then we move into the stage called exploration. Now, exploration, if I'm honest, is a stage that the legal system does not lend itself well to. What happens, usually in a lot of cases, is that the parties will exchange their opening gambit, but when it comes to actually then spending some time exploring, they say, well, this is our position, this is our position. They jump straight to bargaining. Okay, we'll do this, we'll do that, we'll do this, without actually understanding enough about how that's impacted their position or what the other side's position is to actually be able to inform the bargaining to make it run more smoothly. So what you need to have a think about here is you've just had that opening gambit across from the other side. What issues does that resolve? What does it create? Do we need to review the position? Does it change the objectives? How's the dispute and how's the person on our side of the dispute feeling about that? This should actually realistically be the longest phase of any negotiation, where we're actually taking time to explore with the other side. Okay, well, you said that. Can you give me some more information about that? I really want to understand that. Or, okay, you've mentioned this. Well, I think it might be useful if I tell you that. Because you build up that level of trust again, you build up that communication with the other side. And at that stage, you're just exploring. Nobody's committing to anything. It can be done on a without prejudice basis. But what it does is it just flushes out that broad landscape of the dispute and the issue that you're trying to resolve. This is why most of the pre-action protocols, which have had a lot of input from other disciplines, will have that stage that suggests that there should be a period of reflection before issue. What they're really trying to do is to encourage individuals, companies, and practitioners to just stop, think, is there anything else we need to explore before we start taking this forward? You will find, if you get used to being comfortable with that exploration phase and that approach to dispute resolution, that actually it will line you up for a much cleaner bargaining phase and a much swifter resolution. It also might feel like there are some additional costs with questions and research going on at the beginning for your client, but overall, I can promise you it does save money as well from a client's perspective, because of the fact that there is less time wasted where there are misunderstandings, there is less pushback because the parties have already done that exploration, and generally you get a much quicker solution. You then come on to the bargaining stage. If you've not done the exploration stage, this can be a little bit like horse trading. But what I would say is if you've done the exploration stage, you're clear on your objectives, what negotiation, unlike any of the other forms of dispute resolution, really allows you to do is think outside of the box and get creative in what solutions that you actually want to suggest. You're not bound or limited by prescribed remedies like you are with litigation. The world is your oyster, so if you understand what the problem is, you can really be a craftsman and craft that solution that is actually going to address all of the elements on all of the levels for the parties, so that you can get a solution that really fits, fits the mark. And then finally, obviously, we're generally very good at the concluding stage, which is that clarity of what the solution is we've reached and recording it. It is worth at that stage, though, still stopping and saying, have we actually answered all of the issues? What do we need to anticipate? And one of the things that I've seen in a number of disputes, it particularly comes up in things like boundary disputes, is that if we have got a procedural solution and a substantive solution as to where things are going to go, mainly because the parties have got worried about costs or something like that, we've got a solution and the dispute has, if for all intents and purposes on paper, been resolved. But because the underlying issues were not resolved in the dispute that has been crafted, or the emotions are still running high, actually what happens is 2 weeks later, party A does something to irritate party B retaliates, and it starts snowballing again. So this is why it's worth looking whether we can craft something that is going to answer all of the issues. Where we're in a position where we've not been able to do that, what can we put into the solution that we have got that might anticipate those, so that it makes it easier for the parties to resolve things in future. So looking then at the types of negotiation, there are two types of negotiation that everybody will be familiar with. The first one is the direct negotiation. That could be with face-to-face or it could be through correspondence. That's generally where most people start. It's cheaper, it's ongoing, it doesn't have a fixed end time. But what it can mean is actually that type of negotiation can make that exploration stage quite difficult, because each party will be cautious about showing its hand. They will give you what information they want to give you and withhold what they want to withhold at that stage. And because the parties are talking direct, there's no real digging beneath the surface that can be done. So the other option is what's called a mediated negotiation. Now, that will come at a cost because you've got a third party involved there. But what it does is it's not necessarily a traditional mediation that many of us may immediately think about. It's not necessarily just that, half day, one day where we all go and sit in a room, separate rooms, mediator goes backwards and forwards and actually tries to reach a solution within that fixed time scale. Although that is a very condensed version of how mediated negotiation can work, it does actually get used in a number of different ways. What happens when you've got a mediated negotiation, whether it's in that condensed version or in a different version that we'll come on to discuss in a moment, is that the mediator actually facilitates the exploration on each side. Now, they may not share everything that they learn with the other party, because obviously they only carry back what they've got permission to learn, but it does mean that there is someone prompting and questioning and leading that work on each side to actually get that exploration going, to get those thoughts going about the objectives, about what's really going on here, where do we really want to get to. There is someone also there encouraging the parties to share and creating a safe space for them to put some more cards on the table. The other thing that a mediator is invaluable for is helping parties to phrase offers in the bargaining stage. Now, bearing in mind, they will have an intimate understanding of that private exploration on each side. Now, they may not share what they know, but they are able to give advice on how to phrase or how to craft offers that may be more palatable to the other side. So if you can trust a mediator who's sat in the middle to say, I trust you to take this across and phrase it in the best way and put it to the other party in a way that's going to be best received, they are very well placed to do that, which direct negotiation is not going to give you. And because of the fact that there's that greater exploration, that encouragement to share, and that ability to phrase the bargaining phase in a much better way, this is why mediated settlement actually is great for breaking deadlock and has a much higher prospect of success. So as I said, negotiation is just one way you can approach things. The other thing that you can think about is obviously alternative dispute resolution. Now, there are a number of different types of ADR, and I'm sure many of us will be familiar with going through the process where you say, well, this is what this is, and this is the pros and cons of why I might want to use that. But actually, probably a lot of us haven't thought about which of these are going to be, in the context of what we've been talking about, the most effective ways of actually resolving the problem. So the first things that we'll start with here is looking at the variance on litigation. Now, arbitration is essentially private litigation. It follows much of the same process. It's quicker because you're not waiting for the court to have the facilities to hear the case or to run their timetable. And it's kept private. It's not in the public domain. You can also choose who your arbitrator is. So if it's something that needs someone perhaps with a bit more of a specialist background, you've got the option to do that. There's a variation on that that's called high-low arbitration, which is where the parties fix the parameters in which the arbitrator is allowed to make a decision. Another variation on that is what's called MEDARB, which is mediated arbitration. And what that is you have a mediation, and any points that are not resolved at the mediation then go straight into an arbitration once they've been narrowed down. Now, that's all great. In terms of you get an answer at the end of it. The answer is binding out of arbitration as well. I'm very similar to litigation. In litigation, you've only got a limited range of remedies. Arbitration, a bit more flexibility, but not a huge amount. Now, the problem with that is that process will address your procedural and your substantive levels of solving your problem. Very rarely does it resolve the emotional or the psychological issues, although people may feel that they've had their day in court, which may be all that they wanted. They just wanted to be heard. So that's something to bear in mind when you're looking at that, as well as looking at the costs and so on. You've then got the binding decisions from third parties. These tend to be schemes that have been set up. So you've got a number of adjudication schemes that run in this country. So things like for flights, for new houses, and so on. And what those are is they're generally the parties will submit their cases on paper to an adjudicator of the relevant scheme. The adjudicator looks at the matter on paper and gives a judgment. Gives you the answer again in terms of answering your procedural and your substantive, but possibly the parties may feel like they've not been heard, or that the adjudicator's not potentially understood the emphasis from the documentation. It's quite an arm's length process, which may not give them what they need. And it's really only appropriate for much smaller matters that can be dealt with quite quickly on paper. You've got expert determination, which a lot of us will be familiar with. This is when you appoint a single expert. Both parties, again, submit their paperwork. That expert then gives their expert opinion. But because the parties have agreed to be bound by it, they are then bound by that decision. It has a lot of the same issues that come up with the adjudication of the parties potentially may not feel heard. Ombudsman schemes are another one that tends to fall into this category, but most ombudsman schemes will not consider any complaints unless efforts have been made to resolve the issue first. So you need to have gone through complaints procedures, perhaps undertaken some negotiation first. So you then come on to these alternative dispute resolution non-binding third-party facilitation. Now, these are the ones that I personally think are going to really help you solve the problem. And there's a few different ones here that we've got. The big one that everyone is talking about at the moment is obviously early neutral evaluation. This is when you put the case at an early stage to a judge, and the judge gives you some guidance as to how they might consider finding in that case if it was before them, given the information they've got in front of them. This doesn't necessarily lead to any solution. The judge's musings aren't binding. It's just an indication. It's an early evaluation of where things might go. But what it can do is two things. One, it can really prompt that stage of consideration of a party's case. So if we're looking back at the 5 levels, that exploration stage, the 5 phases of negotiation, what it can really do is really prompt the parties to question, actually, is my case as strong as I thought it was because the judge said this? Now, maybe the party says, well, actually, no, because that's going to be bolstered by the time we've done disclosure and witness evidence. Or it may be that they say, well, actually, maybe that's something I haven't thought about. It's particularly helpful when you have got parties where the emotions are running really, really high. Because what it does is it gives them almost a dummy run at having their day in court, where they get a chance to actually see their case put in front of a judge. And some people, that is something that they need in order to have that release, to get rid of that emotional or psychological block that's built up in order for them to be able to see the wood for the trees. So it can be very useful, but obviously it just informs a negotiation. It doesn't resolve the matter. Mediation, we've already talked about in a bit more detail. Mediation, I think, is one of those things, but I may be prejudiced because I am a mediator, that I think is almost a perfect way of resolving disputes, because it pushes the parties, it coaxes them through those 5 phases, and nothing is binding until a party has actually agreed to it, and parties can craft the solution through that process in any way that they feel like. So it's one of the few areas where you will get a solution out of the other end that actually ticks all 3 boxes of procedural, substantive, and emotional or psychological. So that's why a lot of parties that come out of mediation generally feel a lot happier and a lot more relieved about resolving their dispute than they would if they had gone through any of the other methods. But one of the things that I would say and I use this both with clients as a solicitor with that hat on and also as a mediator, is if you're not sure whether you've quite hit that third level of emotional and psychological, the question that I always ask people is, when you wake up tomorrow morning, how are you going to feel if we've reached this agreement? If the answer is disappointed and unhappy, something hasn't been resolved. If the issue is relieved, I can move on with my life, it's done what it needs to do, you know that you've been able to tick that box. But that's a question that I always ask, even when I think we are completely there, everything has been ticked off, I always do that as my final check, because that will tell me whether we've actually solved the problem in full or not. A couple of other ways of using mediation. I mentioned it could be used in a number of different ways earlier. Project mediation is something that is used. It's used a lot in America, but it's becoming more popular in the UK. And what this is when there is a complex project, what the parties will often do to that project, so all the contractors and everyone else involved in it, or it might be different government departments, they will actually appoint a mediator, a neutral party who is going to be on board from the beginning of that project, understand the project, understand how it develops, and then if there are any disagreements between the parties involved in that project, so for example, who's going to fund what, or something goes wrong and people are saying we've got a problem, before they get into that blame snowball effect, transitioning into things falling apart, if you've got that neutral party that understands everything about the situation, can step in and broker between them a solution, it lets the project keep going, and it gives a lot more fluidity and stops those roadblocks from slowing it down. You can also use it in terms of broker talks. So mediation is used in terms of peace negotiations, as well as brokering agreements between countries, between companies, and so on. Sometimes that's referred to in a commercial context as deal mediation. And again, if you've got a particularly difficult deal that you need to get done, it works in very much the same way. A mediator is that neutral party that can sit there, they can explore with both sides, they can encourage them to share, create that safe space, and they can help take those offers and that negotiation backwards and forwards in a way that's going to be more palatable. So it actually speeds up the deal-making process and again helps parties to craft something that's going to work much better for both sides. And then the final thing to have a think about is your independent review. Now, your independent review, that again, very much like your expert determination, except in this case, it's not binding, has a lot in common with your early neutral evaluation. And is something that is worth considering when both parties are fairly entrenched, saying, well, I think I've read a page of the Daily Mail and I think this, or well, I've read 2 pages of a textbook and I think that. Actually getting an expert in there to give an opinion can sometimes just pull them out of the trenches and help with their exploration phase as well. So that's our ADR stage. Coming on just finally then to litigation. Now, as I said before, this is the last resort. It's expensive, it takes time, it's only got limited remedies, it may not even address, well, it might address things procedurally, it might not give you the substantive answer that you're looking for, and actually very rarely have I ever found anybody who's come out of a courtroom and felt like they've really won. Most people find it to be a thoroughly unpleasant experience and something that they wish that they hadn't gone through. So generally, while it does resolve the dispute technically at law, it doesn't really meet objectives and it doesn't really tick the boxes for solving the problem from a sociological or psychological point of view. But how can you use it? It is a very useful tool. There's a few things you can do with litigation, and sometimes having a litigator who knows how to use this toolbox in this way can be really helpful. Issuing a claim can bring parties to the table. So if you've got parties that aren't taking things seriously, it can bring them to the table to actually prompt negotiations if you can't get them talking to each other. It may be that one party is in complete denial, says there is actually no issue here, why should I bother, and they just don't come to the table. The other thing you can do is you can make strategic offers. You can use Part 36 offers, which obviously come with specific consequences. And what these effectively do is offers increase the risk for the other side. If they don't meet that offer, there is going to be consequences. So they increase risk, and what that does is increases pressure. Now, there are strategic times to use that. If negotiations are going well, people are sharing and everything is going well, there might not be a need to increase pressure. It's usually good to use those to just push things over the line or to move things along when they start slowing down. If you get as far in your directions, so having issued your statements of case, you then get to the point where there is forced disclosure. So if the parties are being very shy about what they're sharing, that forced disclosure, again, it's quite often worth having a gap in directions after disclosure, because quite often the parties need to reevaluate their case, have a think about it, and it's a great time, if you've not managed to get a settlement, to think about possibly another mediation or without prejudice meeting at that stage. And again, often the parties have not left themselves space in the directions they've suggested to do that, and they're already jumping along into trying to get their witness statements and everything else done. So it's worth thinking, after disclosure, leave a space for negotiation if you can. After witness statements, leave a space for negotiation if you can. There may be reasons not to do that if the case or the issue is time sensitive, but if you can afford it, it's worth giving yourself that space. Applications, again, these are another way of adding pressure or obtaining further information. You can make applications for disclosure, applications to say, well, you've done something wrong, applications if somebody's really not pleaded their case very well for summary judgment. There are all sorts of ways you can use this to add pressure as you go along throughout your negotiations. And as I've mentioned there, the thing to bear in mind, though, is that when you are doing your directions, if you get to that stage in litigation, when you are writing directions, most of the time these can be agreed between the parties now, but do allow yourself that extra room in those directions if you can, not only for unforeseen circumstances, people being on holiday, things not being provided on time, that kind of thing, which are the general considerations that we have, but also think, well, actually, if we wanted to try and get all the parties around the table, do we want to allow another week, another extra 2 weeks in there, because there might be another opportunity there for settlement if we get to that stage. So obviously that's been a bit of a whistle-stop tour today. What I'm hoping is that this webinar has really given you a chance to just step back from that usual adversarial way of viewing disputes and actually look at them in a more holistic way. And hopefully what that will do is help you be a bit more creative in your approach and creative in the ways in which you approach settlement and resolving those problems going forwards. As ever, if anybody has any questions, please do give me a call or drop me an email. My details are up there on the screen. And thank you very much for joining me.